Meet Ravi, a talented student who was accepted into a prestigious US university with a partial scholarship. During his visa interview, when asked about his financial situation, Ravi mentioned his family's 12 lakh annual income but forgot to disclose his scholarship. Without this critical detail, the consular officer assumed Ravi lacked sufficient funds and denied his visa under section 212A4, citing concerns about him becoming a public charge. Ravi reapplied, this time providing proof of his scholarship, and visa was approved. If you have faced a similar situation, do not worry. A refusal under section 212A4 isn't permanent. Let's explain what it means and how you can overcome it. A refusal under section 212A4 means the consular officer determined that applicant is likely to become a public charge in the United States. In other words, they believed the applicant might not have enough financial support to sustain themselves and could end up relying on public benefits. The US government wants to ensure that people entering the country, whether temporarily or permanently, can financially support themselves or have someone to support them. That's why financial stability is an important part of the visa application process. Now, is a 212A4 refusal permanent? Not necessarily. This kind of denial can be overcome in certain circumstances, depending on the type of visa being applied for and the evidence provided to demonstrate financial support. For immigration visa applicants, most are required to submit an affidavit of support from the US sponsor who filed their petition. This affidavit is a legal document showing that the sponsor has sufficient income to support the applicant and prevent them from becoming a public charge. If the sponsor doesn't meet the financial requirements, there are still options. For example, the applicant could provide a second affidavit of support from a joint sponsor who qualifies or shows evidence of their own financial resources like savings or assets. For some visa categories like employment-based immigrant visas or diversity visas, the affidavit of support isn't required. In these cases, applications need to demonstrate financial independence or show other means of support such as personal funds, a job offer in the United States, sponsorship from a US resident. This could be someone providing financial support through a letter, transcripts, or other documentations. The consular officer will review whatever additional evidence is provided to decide whether it's enough to overcome the public charge determination. For non-immigrant visa application, the process is slightly different. Public charge refusals are less common in these cases, but they can happen. For example, if an applicant is applying for a visa to seek medical treatment in the US and doesn't have sufficient funds to cover the costs, the officer may determine they are likely to become a public charge. To address this, non-immigrant applications must demonstrate that they have enough financial support for their temporary stay. This might include showing personal funds, proof of sponsorship from a US resident, or evidence that specific costs like medical treatment have already been arranged. So what can be done if a visa has been denied under section 212A4? The good news is additional evidence can be provided to overcome the refusal. Gather documents that show the applicant's financial situation or sponsor's ability to support them and submit them to the consulate. The consular officer will review this new information to decide if it resolves the concern. Here are a few tips to help strengthen a case. If relying on a sponsor, make sure their financial documents are complete and meet the income requirements. If relying on personal funds, provide detailed evidence such as bank statements, property ownership, or proof of income. If there's a job offer in the US, submit a letter from the employer outlining salary and employment terms. Remember, a refusal under section 212A4 is not the end of the road. It's an opportunity to provide additional evidence and demonstrate that the applicant meets the requirements. Every application is reviewed individually, so overcoming this determination depends on the strength of the evidence provided. Thanks for taking the time to learn about 212A4 visa refusals. We hope that this helps clarify the process and what can be done to move forward. Good luck with your application, and remember, we are here to guide you through every step of the way.